Hey, Jocelyn, why don't you go ahead and start admitting people? Hi, friends. This is Claire Courtwright, Policy Director with Cal Voices. We are a start time of noon, so we've got a couple minutes still left for people to join. And I will try to get started right on time or maybe a minute or two late, give folks a chance to join. I know I never join a Zoom until the hair of noon, so. Okay, folks, I'm going to give it one more minute before we get started. Okay, I'm going to go ahead and get started and let my colleague continue to let people into the room so that we're somewhat on time. I'll introduce myself. My name is Claire Courtright. I am the policy director for CalVoices. And I am up here. I'm a person with lived experience of serious mental illness and an attorney, and primarily I work on state level legislation. Some housekeeping, this session is being recorded. We are posting them online. These policy updates and trainings that we do, they're available, I believe, on our YouTube channel. We will also send the slide deck out after this presentation in PDF form, so you can use that as a reference. This policy update is going to really focus on the bills that we've been working on in the legislature and what they're about and what their status is. This quarterly policy update has come pretty soon after the last one. I think we did our last one at the end of,
The end of May.
Yeah, the end of May. And that one really focused heavily, on the sort of larger landscape of everything that's going on in mental health policy. And also to an extent Prop 1. And I have not focused on Prop 1 implementation for this quarterly policy update, but I will likely do something separate relatively soon. But just, there's no slides on it, but I'll just give you sort of orally as best as we know what's going on at this point. When Prop 1 passed, the Behavioral Mental Health Services Act became the Behavioral Health Services Act. And there's, quite a lot of words in the new statute, and there's quite a lot that's not there. So there are significant portions of the BHSA that are quite literally yet to be written. Many major decisions to be made by the state agency that is allowed to make regulations, which is essentially additional law to implement in order to implement the intent of the statute and the substance of the statute. So that is primarily the Department of Healthcare Services, but also with technical assistance from the Mental Health Services Act Oversight and Accountability Commission, if I can speak, the MHSA OAC. I will say that I did check recently to see if anything has issued from DHCS relating to implementation, and I am not seeing anything yet. So how DHCS would release that information is through what's called behavioral health information notices, plan letters or bulletins, all of which, if you Google, are online and you can find everything that's been issued for the year. I'm not seeing anything yet. So if you're still interested in Prop 1 implementation, you're primarily here for that. I will say it really, we don't know, but there are, if you watch the webinars and public listening sessions that have been put out by DHCS on the behavioral health transformation website, that's going to be the most that anybody knows at this point. So I have pretty closely watched those recently, and I will say, they're worth watching, especially the all comers one, the original one that I think was done in June, the beginning of June. In any case, the webinar is referred to as all comers. I think that's the best you're going to get for reading tea leaves as to where those regulations are going. If you're familiar with the MHSA now, there's lots to compare and contrast to. Like, for instance, it seems like the intention of the administration is to completely change what a full service partnership means, who's eligible for it, and create, levels of services within FSPs. So there's a lot of stuff like that, if you're sufficiently familiar now with MHSA and you're listening to what they're saying in these public webinars, you can kind of get a sense of where it's going, even though no new regulations have issued at this time. So as I said, I will put out something, I plan to fairly soon, where I've just done, we've done the thinking around that and listened to what they've said and compared to what's in the MHSA now to try to read those tea leaves about where it's going. I will also say there is no formal public process to really transition from the Mental Health Services Act to the Behavioral Health Services Act. You have MHSA funding allocations and law. The law sort of expires July 1, 2026, and the new law takes effect the same day. So that's obviously, you can't stop and start on a dime. So this process is ongoing. And I will say, if you are wanting a transparent public process, you're going to have to demand it from your county, because there was nothing in the law to create a formal public process for either counties or the state to transition between the two regimes. So that was a lot of talking. For the balance of this webinar, I'm just going over, sort of a handful of bills that we've been heavily involved in working on over this legislative session. The legislature is in recess right now and soon to resume. So most of these bills are sort of in the final form that they will be, because they really only have to go through one more committee about money, most of them. So the substance of the bills are likely set, and it'll just be whether the legislature as a whole votes on them or doesn't vote on them. After each bill, I have built in time for a question and answer period. I'm only working with one screen, so I'll have to come out of full screen mode so that I can see y'all's hands up. Please raise your hands. Please make sure you're on mute. During our second question and answer period about the bills, my colleague Jocelyn is going to launch a questionnaire just to kind of get demographics from y'all as to who's coming to these things and interested in them. So since I've introduced myself, we'll just go to the agenda. These are the bills that, we're only looking at about 5 bills that we've been heavily involved in working on this legislative session. And I will go through each one. I will say also, this does not even come close to all of the mental health legislation that you might be interested in that's currently going through the legislature. They introduce a very large number of bills. And because there is so much that is happening, and has changed and will change in the structure of our, public behavioral health system and our involuntary intervention laws, there's a lot more out there. But this is what, Cal Voices as a small agency has the capacity to pay attention to and be heavily involved in. So I will start with SB 1184. This is a bill from Senator Susan Eggman that, really rolls back some fundamental rights that people with serious mental illness won in a case called Reese versus St. Mary's Hospital and Medical Center. And so anyone familiar with involuntary hospitalization will know that when you get put on hold, it's for danger to self, danger to others, or gravely disabled. And nothing about the criteria of those holds addresses whether or not you are competent to make medical decisions. So Miss Reese was a person who went to a hospital voluntarily, even agreed to take an antipsychotic medication that had caused devastating side effects in the past. And when she experienced them again, she began to refuse the medication. She was then placed on an involuntary hold and injected against her will with medications that cause seizures, amongst other things. So she sued and said, I have a constitutional right to refuse antipsychotic medications even when I'm an involuntary patient. Although the case was decided on statutory grounds, it's partially decided on the basis of the California Constitution's right to privacy and the right of all people in California to have an absolute refusal of unwanted medical treatment unless a judge first determines that you lack decision-making capacity. So this is a very important case, probably one of the best cases I've ever read. And then it's a procedure for complying with the case that said you have to first have these hearings. In that hearing, it's not whether you're incompetent as respects all things or this thing or that thing. It's really medications. It's narrow to the issue. So it's a very important case, and it's some of the fundamental rights of involuntary patients in California. When the holding of the case was sort of translated into a legal procedure in a statute, it said, if you get put on a series of hold, you have to have a new Reese hearing on each hold, and that period of time during which they can consider you incompetent expires when the hold expires. So we have this whole schema, nothing wrong with the statute. I've defended folks on this for a long time. And so, you know, it's really just a matter, as you move from one hold to the next, it's just a matter of the psychiatrist filing a new petition timely if he feels that you continue to lack decision-making capacity. And then the court needs to hear it timely, and there are strict rules in the law for timeliness, and no day of the week is exempted. So really, there's you know, there's really nothing wrong with the law in terms of if you're moving from one hold to another, that those involuntary medication orders, or you might win the case, are seamless. So, but you know, as so many bills in
Claire, I just
California,
wanted to let you know that you're sharing your entire screen with all of the slides at the bottom.
I'm sorry.
You've been sharing your entire screen with all the slides at the bottom, so it was just a little square. So I just didn't know if you were aware of that.
Oh, are you not? You're not seeing it in full screen mode?
No, it's showing a smaller version
Mm.
of the slide, and then okay, well it just changed to now. If you go down to the bottom where it looks like a little book, that's the one that's going to give you your
No, I did the
so that it doesn't show the slides on the side if you
Mm.
want. And now it's back to the
Also,
one with the
Sarah,
one on the side. Just an FYI. for you.
Sarah's had his hand up for a hot minute there too.
Yeah, I'm gonna have to take questions periodically after, because I'm only working on one screen. So after this bill, I will take questions. My wonderful coworker Steph is here to help me.
Okay, I can
I
great.
get an F
You-
in surviving the pandemic, because I truly don't know how to use Zoom well.
Yeah, so sorry, Claire. I didn't mean to interrupt your flow. I just
No,
didn't
you're totally
you
fine. I
wanted it
appreciate
like
you.
that.
I should have done a check-in at the beginning to make sure that you were seeing the screen properly, because I could, and I assumed you could.
You just had the screen looking right and now it's back to what it was before. So whatever you did, you fixed it, but now it's not fixed. There we go. That's
Perfect.
perfect. You got it.
I actually foresaw this. Thought this might happen. Thank you, Steph.
It looks great.
Is it still great?
Yes,
Is
it
it still-
does. It looks great.
All right. Thank you. I appreciate you. All right, let me zoom forward. Okay, so unfortunately, you know, this bill has really followed a pattern where people are asking to change the law or change fundamental rights for people with serious mental illness, and they're not bringing any data. So, you know, we keep making laws in California based on, you know, negative stereotypes and anecdotes about people with serious mental illness. So we really objected strongly to this bill this time. Because the basis of it, you know, the bill was brought by a senator, but it has what's called a sponsor, which means that an entity, a private entity outside the legislature wanted this bill to happen. And the sponsors are two psychiatric physicians trade associations. And they say, look, you know, we're running into this problem basically in some, you know, counties in Southern California where they never say why. They just say there's, you know, the hearings aren't happening seamlessly. So there's a time during which I don't have an active involuntary medication order as you move from one hold to the next. And as a result of that, there are quote unquote gaps in treatment. I can't involuntarily medicate this person, and people decompensate. And over time, their testimony about this gap has changed a lot, and it's narrowed. And so, you know, we really objected to this because frankly, we saw it all last year, and we've seen it since Care Court, where we're making sweeping changes to the law and they're not bringing a single shred of data. And you know, so I think the opposition really said, you know, if there's a problem with the administrative functioning of the courts and hearings aren't happening timely, or doctors aren't filing petitions timely, that has nothing to do with the patient, and patients shouldn't lose fundamental constitutional rights. But it's difficult to get the legislature on your side because we're not a population of people that seems to be included at this time in you know, the generalized interest in protecting marginalized populations. So the original bill actually would have said, okay, you know, you go into the hospital, you're on a 5150. Before you have any medications, you're refusing those medications. They get an involuntary medication order. Now that medication order can last the rest of the time for the maximum you could be in the hospital, which is 77 days with no repeat hearings, even though these drugs are supposed to treat psychosis and restore competency. So it's pretty outrageous in its original form. You know, we strenuously objected, so did most of our partner organizations. And those are some of the bases for them. Ultimately, we were able to get amendments out of the Judiciary Committee that returned all the rights to hearings, but gave these doctors sort of a grace period to keep doing involuntary medications while a hearing is pending if the hearing is not timely. And we're like, no, we don't like that either, because it shouldn't be on the patient if the courts or doctors aren't holding timely hearings, and you're disadvantaging the patient still. And, you know, giving them more time or disadvantaging the patient really doesn't solve the issue, because the issue is somebody's not complying with the existing statute. So we got more amendments out of the Assembly Judiciary Committee. And although they kept the same grace period that the Senate Judiciary Committee insisted upon, they added exigent circumstances. So now if a doctor is going to try to get a grace period between holds to continue involuntary medications, they have to attest to exigent circumstances. I feel like it's a little fancy without a lot of substance, unfortunately. But they also have to report this to the California Judicial Council. They have to start tracking these things. If they're going to claim that there's an issue, you know, that is systemic and statewide that justifies taking people's fundamental rights, they ought to have some reason to say so. So there's data reporting in the bill now, and the law sunsets. So I've seen them give us this concession repeatedly this year where, so, you know, if this gets voted into law, this law expires. So this change to the law would expire and revert back in 2030. And that's to give time to, like, you know, sort of gather the data that should have been there to justify it in the first place. But it is somewhat better than it was originally in its original form. And it complicates proceedings, unfortunately. But that is SB 1184. It is now going to the Appropriations Committee because the data reporting requirements means it costs money. And so the Money Committee has to look at it, and we will see if it survives the Money Committee in this during this budget deficit. And I have hopefully come off full screen. I can see y'all now. And does anyone have any questions about SB 1184?
Well, I have a comment. Can you please, when we switched the screen, we went back to the first slide and we didn't get the slides that you had about the bill, and now we have questions and discussions. I heard what you're saying, but can we get the technology so that the slides are advancing as you're talking?
Well, they should have. I thought that
Yeah, we didn't, when we had it, it went back to the original slide, and this one kind of got lost. But that's okay. I just wanted to give
are you able to see it right now are you able to see these slides as I'm fairly large?
I'm able to see now the SB 1184 slide.
Okay, you know what? I'm not going to mess with going in full screen then. I'll just keep doing this.
Okay.
Let me see if I can unmute folks. Actually, Jocelyn, can you unmute folks for me? Or actually, I might be able to.
I see that Sari has their hand up. I hope
Yeah.
I pronounced that correct.
Sari, are you able to come off mute?
Yeah, I can wait. I don't particularly have the comment or question to the subject that you are talking right now, but I have something else. I can wait at the end.
That's okay. You can throw it in now. We're at a pause point.
Because I just received the email from the California grant that they sent out yesterday, and then they make a public announcement. They have over $1.4 billion to give out to the county, but it go to the competitive grant competition. And it's also related to Proposition 1.
Oh, there's
Th-
some grant
we have-
money going out from Proposition 1. The only thing that I am,
Yeah, They already
aware-
got the
go ahead.
money.
Yeah, so what I am aware of with respect to money going out now is they are making an early distribution of monies that were under the bond. I don't know how they're legally able to do that because they haven't sold the bonds, but there was a 6.3, 6.8
$6.3
bond. at top one.
billion.
Yeah. So, yes, the state of California is releasing early, some of the bond funds this summer. And those relate to clinical treatment facilities. And those monies can be, they're grants. So they give away cash for the purpose of building clinical treatment facilities. And that cash can go to both public or private entities. So, your county or a tribal entity could apply during this summer to get a grant to build some of the eligible clinical treatment facility types that can be built under the bond, under the Behavioral Health Continuum Infrastructure Program. So that's the money that they're talking about releasing early. With respect to monies appropriated through the tax on the MHSA and the that exists now, they can't touch any of that until 2026. Does that make sense?
Thank you.
You're welcome. Anybody else have questions about SB 1184? Okay.
Well,
Since
I have a question. This is Steve McNally in Orange County.
Hey, Steve, go ahead.
Claire. So I'm looking at who's supporting the bill, and it's these 4 psychiatrists organizations,
Yeah.
but nobody else that seems to be involved with mental health as a position one way or the other, CBHDA or
Yeah, no courts, no counties,
Yeah,
no
so
county mental health plans,
that
not
seems sort
judicial
of odd to
council.
me.
I'm sorry,
Shouldn't-
go.
I mean, doesn't that seem odd given that they're really struck with helping to implement this kind of stuff?
It does not strike me as odd because I'm kind of used to it. I think legislators are usually looking to, they run bills. That's what they do, right? So, Senator Eggman has been the author behind everything pretty much. And so it's not unusual for her to, run a mental health bill, just as that's sort of her mainstay. I think, I don't think she understands anything about this. And so I think she sort of heavily relied on the sponsors to say what the law is and the procedure is, and they've been consistently incorrect. But the idea that, you would see a fundamental, you would see our fundamental rights kind of on the chopping block on such a thin basis from sort of interested parties of the psychiatric, I think it's the Psychiatric Physicians Alliance of California, I think it's FAC, and Randall Hagar's group, happens quite a bit, and it needs to stop. I will say, I think, this business of making massive policy changes or things that affect people's bodies and lives without any kind of, evidence base is something that they know is a problem. And it's why they keep sticking these data reporting requirements in the bill, because they're going to go, it's a sort of concession that they know that they're not making major policy decisions based on data, but I'm used to it,
Right.
Steve. Anybody else have a question?
Well, I get the part that you're used to it, but is there something you'd like us to do, like to inform our
Yeah.
legislators or give them a fact sheet or something?
Yeah, this, this forum is less for us to sort of, it's for an advocacy grant to more give information. I don't know, we're not going to direct what
Okay,
position
got
or
it.
how
All
people
right.
feel about the bill. But if you do oppose the bill, you can absolutely always call your state senator, state assembly person, and say, hey, what the heck? You're welcome to do that. Okay, since I
All right,
am
thank
not,
you.
You're welcome. Since I am not savvy enough to figure out how to go in full screen, but y'all can see this relatively large. Is that
Yes,
correct?
and
Okay, then we will go this way.
Good.
So we have another, one of the other major sort of, I think the Reese bill is very important because it disturbs it disturbs a case, and that case is still good law, but this is a much more sweeping change, and SB 402 from Senator Wahab, who's from, Alameda County, Santa Clara County area, represents that area. This is a real sweeping change, and it is a change to who can initiate a 5150 hold in the law. So currently, in order for a mental health professional to place a 5150, they can only do so in their capacity of being an employee for a facility, like an emergency room or a psych hospital or a crisis stabilization unit, or designated members of a mobile crisis unit. And outside of those mental health professionals, the only other people that can place 5150 holds are law enforcement. Mental health professionals, when they want to place 5150 holds, are under the auspices of the county. The county has to allow it. The county has to train them. Supposedly the counties monitor them, although I've never seen any evidence of it. But the cops are completely their own thing. They're right in the statute. They don't have to, they aren't under the auspices of the county. They can automatically write holds by virtue of being a police officer. So what this law does is, it expands the ability to write a 5150 hold to mental health professionals in their private practice, meaning not in their capacity as working for an emergency room or general acute care hospital or psych hospital. So we're talking, your therapist, your psychologist, your psychiatrist in their private practice, in their private offices out in the community, including if they're employed by no one, they're self-employed, including if if they're writing a hold on someone, it's not even their client, they don't have a client provider relationship with. So it's way overbroad. And it's, again, if Steve pulls up the bill, he'll find out no one was clamoring for this one either. The statement of the bill's purpose is to get law enforcement, reduce the role of law enforcement in holds, which, certainly is desirable, but this bill doesn't do that because it doesn't affect at all the ability of police officers to write holds. It's just a net more people, right? It's just additional people who can write holds. And, you hope that there's some substitution process where, it's mental health professionals and not police officers who are initiating holds. But the secondary problem with this law is, okay, you have to imagine how this really works in practice, which is you're at your therapist's office out in the community. They decide to place a 5150 hold on you. Who are they going to call to get you to that hospital? Who are they going to call if they look at you and say, I think she might get very upset, and I think she might run away, or I think she might hit? They can only call the police. That's right. So us and the ACLU, who's been super strong on this, are not in favor of this bill because it is not neutral on police. It necessarily increases the involvement of police. It necessarily, we don't even know how many mental health professionals would be able to be 5150 designated because of this law. We don't know how many thousands or hundreds of thousands more people will have this authority, or could have this authority. We also have concerns because there's really no way, the county gives you the designation, so the county might train you and give you your authorization. And, I've done these. So, in the county where I worked, the ability your authorization to write these holds lasts a year, and then you have to retrain and everything. But there's no way for the county to monitor the quality or appropriateness of 5150 holds written by people that don't work for the county, don't work for anybody. They're out in the field. No one tracks these holds. There are no lawsuits because of the civil immunities. There are no lawsuits because they're not state actors for the purposes of civil rights laws. So it really creates this potentially creates a very large number of completely unaccountable people who can sort of rove around and write 5150s on anyone they want. I do not know that this bill will make it through a floor vote. I can say just about every lawmaker that has commented on this bill, although they are not voting against it very consistently, or really at all, have said this bill has massive problems. We don't like it. And so we don't know. It also got some bells and whistles that made it fiscal. So it is going to appropriations, and then it is going to a floor vote. Any questions about that? No.
Is this in addition to the provisions in SB 43?
You're very smart, Mary Jo. You're picking up on it. That's
Well, I've had my eye on this stuff because I'm co-chair of the peer council in San Diego,
I see.
and I'm trying to pull up our army, and I'm trying to get informed on what's happening at the state level. So
Right.
I'm one step ahead. So I know what is coming down from the county, from the state, so I can make the county be accountable. So
That's great to hear. Yeah, I think you're correct. I think the real motivation for this bill is that we greatly expanded the who can be placed on a hold to include folks with substance use disorders. And we know that the target population for SB 43 is the unhoused with substance use disorders. And currently the restriction to place holds, currently the people who can sort of roving place holds are cops and mobile crisis, designated mobile crisis. So this bill, you know, and I have objected to that. So has Disability Rights California. We said, look, you're letting all these specified people sort of, you know, go around and write holds on people they do not know, that are not their clients. I do not see anything that prevents that. And I suspect, I mean, it is a speculation, but I suspect that part of the motivation for this is, you know, to go be able to write, to kind of, to have roving people, to really open up the ability to go write holds on the streets for folks with SUD and the unhoused, especially. That's where I see this going. I would also comment that I just lost my train of thought. Oh, you asked, I was going to comment that I'm looking at another bill that caught my eye that is essentially about the scope of practice of mental health professionals too, because it's been an open question. Who's qualified to place an SUD hold, a substance use disorder hold? Who's qualified to determine that you actually have a substance use disorder? Because not just the same, the substance use disorder is not the same thing as just using drugs or being intoxicated right now. It actually requires a lengthy history of specific patterns of use of drugs and functional impairments, right? So this is not something that, and it's one of the things we objected to in SB 43. It's like you're putting this ability to write substance use disorder holds into the hands of police. These people know absolutely nothing about this. You know, in some ways, it's more intuitive, or one might be able to more easily reasonably suspect that a mental illness might be before you in a person, but SUD isn't like that. And so, yeah, Mary Jo, I do kind of see that's where it's going, that they want sort of a larger number of people able to place holds because they plan to pick a lot of these folks up, and there's limited parties who can do that at the street level. That was a lot of talking. Anybody else have questions?
Hi, this is Sharon Wolf up in Humboldt County, and I just wondered, what's the bill number of that one you just mentioned on the SUD hold?
Well, yeah, I mean, this would apply to all 5150s, so it would apply to SUD as well necessarily. It's Senate Bill 402 by Wahab. Did you
Thank you.
catch it? Okay, I'm going to, and I truly don't know, because I think a lot of people have concerns about this bill in the legislature, whether this one's gonna pass or not. We shall see. But I believe we also, going back, yeah, I'm not sure. There were some amendments to it that I haven't fully digest it, but in substance, that's still what it is. Okay, this is also for folks who are at the county level wanting to know what's coming down from the state. This is a very important bill and somewhat of a mysterious bill. This is Senate Bill 1238, also from Senator Eggman, and what it relates to is Lanterman Petra Short Act county designated facilities. So right now, if you get placed on an involuntary hold, the law says you have to go to an LPS designated facility. They can't just take you anywhere on a psych hold. You have to go to a general acute care hospital that is able to also treat psychiatric illnesses, or you have to go to a mental hospital or a crisis stabilization unit. There's limited, there are limited places that you're permitted to go, and that's for a reason, right? Because the facility needs to be it needs to be regulated. The quality and safety of the care that you are getting need to be regulated. And that's sort of what's wrapped into the idea of a designated facility. Now, when they passed Senate Bill 43 last year, we pointed out to them, you did not update the definition of a designated facility. You've got all these folks with SUD you can pick up, but according to law, you can only take them to a mental health treatment facility as defined in the law. So this is one of the reasons they legally could not implement this law, and why 56 of 58 counties said, no, we're pushing it off. And even the counties that are implementing it, to my knowledge, they have picked no one up on an SUD hold. And that's San Luis Obispo in San Francisco that decided to implement the law. But again, to my knowledge, no one with SUD has actually been picked up, partially because we don't know where they're going, right? Like, where will you be taken for, forced drug treatment? We don't know who's qualified to provide that treatment. We don't know what is that actual treatment. What is involuntary substance use disorder treatment? We don't really know, et cetera, right? So this has been very much under construction, the whole substance use disorder piece for involuntary. And that's what this bill is about. So, basically, I already covered what the problem is. We're able to pick up, not only are we able to pick up folks with only a substance use disorder and no mental illness, but the way that Senate Bill 43 expanded the law, we're also picking up a population of people that are physically ill, right? You can have a substance use disorder and a serious medical condition, which is defined as your life's at risk, your limbs at risk, your organs at risk without appropriate treatment. So we are picking up acutely addicted and, acutely addicted, acutely intoxicated, medically fragile people right off the street. Where are they going? And again, so that's one of our big concerns with this bill, is they seem to just be winging it. So the statement of the bill's purpose is essentially, we need to send these folks with SUD that we can pick up involuntarily somewhere. And we're trying to say what those places are. And the original bill just really kicked it down to the counties. Well, if you pick up a person with a substance use disorder for involuntary treatment, the county can designate any facility that has appropriate services or personnel or whatever, but there was no definition to that, right? So what they were testifying to in this bill is like, the counties can just put a lock on a nursing home and put people there. It was that wild. So, again, we strenuously objected that you're intentionally picking up medically fragile people who need medical detoxification, people with mental illness and serious physical conditions, and you cannot wing it, right? You can't just make it up as you go along, and you can't allow the counties to simply say, well, we put a lock on this nursing home door and now we can use it for this purpose and everything's going to be fine. And there's no regulations about what that care is that you're getting inside that locked facility. When is it enough? When do you get released? None of it is really formed. So originally the bill was pretty absurd on its face. And it also very concerningly identified a bunch of unlocked voluntary infrastructure that we have, essentially saying it can just be converted to locked infrastructure. So one of our big concerns with this bill is that is what it is authorizing. It is authorizing unlocked voluntary clinical treatment facility infrastructure to be converted for the purposes of implementing SB 43. So, you know, you can peruse these at your leisure, but I kind of went over what the objections are to this bill. There's also some pretty serious objections related to federal law. And on it goes. I will say they gutted and amended it at the end of June, and I still haven't fully digested it. But if you're concerned with the disappearance of voluntary infrastructure, voluntary clinical treatment in your community, this is what could potentially be converted. Psychiatric health facilities, most of those are what we call IMDs. They may be locked, they may be unlocked. There may be 16 beds. They may not be an IMD because it might be under 16 beds, but psychiatric health facilities may or may not be locked, right? So you might have one of these facilities in your county that is not locked, and it could potentially become locked, and that might be of concern to you. Also, anything that qualifies as a psychiatric residential treatment facility can now be a locked facility under this bill. Mental health rehabilitation centers, many of which are unlocked. I worked at one that was really just, you know, an 80-bed boarding care. That's a facility that could now be converted to locked. Also, anything Medi-Cal site certified, that's a broad, it's basically any facility that can bill Medi-Cal. So like crisis residentials that are unlocked, they're voluntary step up, step down, could potentially become locked facilities under this bill. General acute care hospitals have always been able to do involuntary treatment. Chemical dependency recovery hospital, that is currently, currently an unlocked. There's several of them that qualify in the state and they are unlocked. So those could become locked. And then, you know, anything the VA is doing, any VA infrastructure, Veterans Affairs. There were some amendments besides the gut and amend that we're still trying to figure out everything it does from June. The bill also said that the Department of Healthcare Services basically needs to make some regulations around substance use disorder treatment and what it's going to mean involuntary treatment. And it must consult the California Behavioral Health Directors Association, patient rights, which means your local county patient rights offices, but also Disability Rights California's Office of Patient Rights, disability rights advocates, providers, and quote, other relevant stakeholders. Of course, once again, you know, persons with lived experience of substance use disorder or mental illness are not included in the list of people that should be consulted. So that's also a concern. Any questions about that?
I'm going to launch the poll here as people are formulating their questions.
Good for you. Thank you, Jocelyn. I'll give you all a chance to do the poll, and then it's just 2 short bills and we should be done by 1. Okay, I'm going to go into the next one just for the sake of time. We also worked a little bit on AB 2352, the mental health and psychiatric advanced directives. And this was an attempt, there's a technological platform. It sort of looks like, you know, Facebook, that was developed by the MHSA OAC to host PADs, to host psychiatric advanced directives. Psychiatric advanced directives are just a nickname for an advanced healthcare directive that primarily deals with medical decision-making around psychiatric care. So everywhere in the country and in California, you can make a sort of like a will, about what you want to happen in your medical care in the event that you become incapacitated, like you're knocked out from a car accident or something, or temporarily incompetent or permanently incompetent. So people use these to keep their right to make medical decisions and, you know, not have their doctor take over those decisions in the event that they're incapacitated or incompetent. So it's a really promising legal vehicle for people with serious mental illness to keep their bodily autonomy in the event that they're not doing well. Because these are legally binding, technically, on healthcare providers only, not people like police, but healthcare providers. But this bill had a lot of real bad technical difficulties with it, where what they were trying to do was not reflected in the bill language, and it was going to not be a great bill. And kind of do some damage to psychiatric advance directives. So we offered some pretty extensive amendments, and I think folks kind of realized that they needed to go back to the substantially go back to the drawing board on how to get the right language into the law to make it do what we want it to do. So the author ended up just pulling the bill, which they're allowed to do, saying, you know what, actually we'll do this later. And then it failed the deadline. So this one is not an active bill for this year, but we will look closely at this because this is very promising for folks, right? Because if you think about this, right, it could be used to potentially keep your autonomy in the event that you know, you're not doing well and you've decided, you know, these are the medications I want to take or don't want to take, or actually don't take me to a mental hospital. I want to go to my aunt's house, and, you know, she's agreed to supervise me and provide for my care in the instance that I'm not doing well. And, you know, you're a medical provider, you're bound by this. So, you know, I don't think you can put me in the hospital. You'd have to legally challenge that. It would be interesting. But in any case, I'm rambling. But psychiatric advance directives are very, very promising vehicle for folks like me who, you know, go through periods where I may not be completely competent with respect to all decisions in my life. And it would be a way for me to keep my right to make medical decisions in those instances. And I will take questions. Looks like Eva has a question.
Hi, I'm Eva. I'm a peer support specialist for Sac County, and we have been lifting the pads up, and we are hosting a pads presentation next week. I did note that in the chat, but I will be attaching the flyer for anyone who is interested in attending and learning more about pads.
Awesome. Thank you so much, Eva. Yeah, I will say I first learned about them from Lori Hallmark, who's a friend of mine and a lawyer from Texas who really pioneered these in Texas. And like the work that she did was incredible around the use of psychiatric advance directives. And there, you know, there's all kinds of things you can do with them and we could do with them, and potentially, you know, develop them into being even more sort of primary, legally enforceable and mainstreamed, used. So
Yes.
Awesome. Thank you, Eva.
Yes, and it's been lifted, you know, throughout the country, but so this is happening, you know, everywhere. So it's being introduced everywhere. So it's for, you know, just for, I know for Sac County we're doing this, but I'm pretty sure other counties is doing it as well.
Yeah, awesome. Thank you for sharing. And Mary Jo, you have a question?
Yeah, just who's sponsoring the bill?
Well, I don't think there was a
Oh,
sponsor.
it's been pulled. It's been pulled.
It's been pulled. The author pulled it. So, but the sponsor, I mean, the sponsor, I guess, was the woman who had primarily worked on the technology pads project for the MHSA OAC, but I don't think there was any other sponsor besides that.
I meant author. That's what I meant.
Oh, the author.
Yeah.
Well, the author technically is Jackie Irwin from Thousand Oaks, I think. But she didn't draft the language on it. It was her sponsor who did.
Okay. All right.
And Tiffany, you want to go?
Yeah, I just wanted to make a quick comment because I know that we've been working at Painted Brain on psychiatric advance directives. There's so much promise in what PADS can do for people who have, mental health and substance use challenges. One of the things that became contentious was the idea that, law enforcement might have access to certain information. But the thing is that we know that a lot of people asked for that, people who have been justice involved, who
Yeah.
said, it's important that this information or that information, I want the police to know that I'm a domestic violence survivor, that I have autism and might go nonverbal, that I have this or that, I have a medical condition that might cause what look like psych symptoms. And so we're hoping that in the future version of the bill that, we'll be able to really get this pushed forward, because there is so much good, and with the understanding that we are always going to be standing for the rights of peers, and that we want to see people able to opt in to sharing certain information if they want to.
Yeah, absolutely. It's a really important topic, and it's definitely it definitely sparks a lot of conversation in the peer community because of people's varying experiences with police. And I think the problem with this bill wasn't it was that there were changes made to the probate code that made PADS less enforceable and also really ambiguous as to when they could be used or even accessed. It was a lot of technical stuff, and I think they should absolutely run a bill next year. But they need to have somebody that really knows the probate code to like draft that properly. And yes, and then yeah, you need proper disclosures. Steve, you want to go?
Yes, this is an area that's really bothersome to me. For the fact that PADS have been around a long time. Everyone can have a PAD now, period. You can present a PAD. But the thing that, and I agree, she's smart, she's terrific, she's the brightest star of the whole project in my eyes, but they're also not enforceable because they can be overridden when you get to the facility. And
Well,
it's
I mean,
doubtful.
I will
Hold on.
say, Steve, ain't nobody
Well-
sued yet.
Well, no, that currently they're unenforceable unless the law changes to be enforceable. You can't a medical doctor, I could be wrong, but my understanding is a medical doctor can override. Also, law is going to require you be taken to where the nearest bed is. So you can, unless you change those factors, I think this is being oversold. And my tracking of the PADS project is very little has been done within the wellness centers or the peer respites or whatever in the communities to have people embrace peers, much like they might embrace a BRAP program. And so my concern isn't that PADS aren't a terrific tool, but there's been nothing stopping us since the early 90s from doing them. And the fact that and so anyway, that's my concern. So, and
Yeah, I
think
hear you. And I mean, I think it's something, there's some words in a law, and then there's the way that doctors interpret them. But who gets the final say is really a court. And I have not seen anybody sue. And where I would like to see them develop into is the ability to override involuntary stuff, right? Because there's no real good reason not to. We let everybody else do this, right? But I hear you. I can see how they could interpret it as like, okay, you're supposed to, I mean, the background is that the background is something very simple, right? Our California Constitution gives us an absolute right to refuse unwanted medical treatment in the event that we're competent. And so all a psychiatric advanced directive or an advanced healthcare directive does is allow you to preserve that and make a decision for the future in the event that you're incompetent. So when they're coming back to us and saying, oh, but the doctor thinks this is medically necessary. Oh, no. If we have literal equal constitutional rights to other folks in advanced healthcare directives that are enforceable, I don't think the doctor can. But someone would need to take that through the courts. But, one of the outs in advanced healthcare directives is if your decision is not something that would be considered you know, a generally accepted standard of medicine, right? Like if you put in your advanced healthcare directive, you know, in the event that I'm in a car accident, cut my head off. You know, the doctor doesn't have to do that because that's not a generally accepted standard of practice. So there may be some outs, Steve, that people are, you know, legitimately pointing to, but I don't think it's a dead issue that they're unenforceable. But I think you'd have to sue. But
Yeah,
I mean,
I
you could
just,
also change the statute, but another way would
yeah,
be,
I guess it's just something that doesn't seem to get as much play as I think is needed.
I agree. But,
And,
you know, yeah,
and then the other part of it is, I never understood why Orange County wants to spend all this money on the technology part of this, when Sam's already has an online, I mean, as a phone app for, and it may be not as good, I don't know, but this whole thing of, because this is a very old project in our county, and I don't understand why we just don't add a psychiatric page to the advanced directive and put it on the Secretary of State website and call it a day right now, while we continue to try to make it a better product.
yeah.
So,
I mean, I have no insight into the tech aspect of it. Stuff, my eyes glaze over on that, but
I might
um,
be able to clarify just a little because there is an innovations project to incorporate the technology. So that's that's where the technology aspect is coming from.
got it. Okay, we are short on time, so I'm going to zoom through the next one. Tom Umberg sneak attacked us is what he does. So there's another tweak to Care Court, and we have asked that he not drop them in floor amendments with no notice to us and have a normal process for a bill. You know, it's really, I mean, at this point, Care Court has a lot of bad press. We're supposed to have somewhere between 7,000 and 12,000 petitions in the first year because our streets are full of our folks menacing people allegedly. You know, and Care Court has only, I think, is somewhere on the order of 300 to 400 petitions, and like 25% of them aren't any good. And the rest are sort of moving through slowly. So there's a lot of bad press around Care Court. Families are also disappointed with it because, you know, their loved ones are still ending up in jail, or they feel that Care Court doesn't have enough teeth. And so really this bill came from family complaints in the media. You know, family members going to the media and saying, I filed this Care Court petition and I was substituted out for the county, which they legally have to do, right? You can't have a private prosecution. Your mom can't prosecute you all the way through Care Court. They have to have a substitute petitioner process. So, you know, if your mom files the petition and the petition looks okay, then your mom is replaced with the county. Your mom's not in the case anymore. So, but families want to know what's going on, and other people want to know what's going on. This bill doesn't just apply to family members. It applies to law enforcement, whoever the private party petitioner was that brought you into Care Court and is no longer in the case. That's who this bill applies to. And what this bill does is basically the judge in Care Court under the existing law can say, okay, your mom petitioned you in, now the county is prosecuting you, but we're going to keep telling your mom what's going on in the case. The judge in their discretion can do that. Under the CARE Act and some things that were tweaked last year. This year they came back and they've changed it to a mandate. So now the judges have to tell the non-party petitioners what is happening in the case, outcomes. Supposedly it won't involve the disclosure of HIPAA protected information, your federal medical privacy rights, or your California state privacy rights. But I think it still does. I think that if you disclose, you know, someone entered into a care agreement. Well, in order for them to enter into a care agreement, that means they must have a schizophrenia spectrum disorder diagnosis. And if you're going to go put the seal of the state of California on a document and hand it back to a family member that says, you know, your loved one entered into a care agreement, that is a confirmation of their diagnosis. That is a confirmation of their private medical information. And someone armed with that document about you could do enormous damage to your life. So, you know, but this was dropped in a floor amendment, so it only went through one committee. I think I was the only person to testify in opposition to it. Oh no, actually, I think ACLU did too. But it'll probably sail through like all the tweaks to care court, but you know, it's unfortunate that, you know, again, we're losing rights because of, you know, care court having bad press. But that is it for the bills that we have recently worked on. And we're just after 1 o'clock, and y'all can drop off if you want, or if you want to stay for a few minutes. I'm here for questions or any other thoughts that you want to add at this time. And I will soon be doing specific Prop 1 implementation stuff. Tanya, hey.
Hey, what happens to those that were misdiagnosed as bipolar and schizophrenic though, and it's still on their medical records?
It's a good point. There's not a lot of quality control in these court systems. They just go on things that have been said in the past a lot of times, but you know, if you have something to point to say it was a misdiagnosis, you might be able to slip out of the situation. But care court does only apply to schizophrenia spectrum, other psychotic disorders, which does not include bipolar or major depressive disorder with psychosis or PTSD or really any of that.
Yeah, it's on my record. Schizophrenia and bipolar. And is there a law or something that we can, like action we can take to be able to clear people's records that have misdiagnoses on them?
You know, a friend was just asking me about this. There's not, but you do have a right in the Health and Safety Code in California to add addendums to your medical records, 250 words for each item you want to comment on. And, you know, if you have somebody else saying you absolutely don't have this, you could stick it in that medical record. But I have a friend that's dealing with this right now because she's like, this is causing me all kinds of problems and jeopardizes my jobs because we're discriminated against in our jobs. So yeah, no, it's definitely it's definitely a thing. And you know, that's something that we should definitely think about, because I have friends with substance use disorders too, where once that's in your record, in your medical records, that is very discrediting for some people and very stigmatized.
Yeah, because I went to the hospital screaming in pain, and instead of them helping me, he said, "Oh, you have mental health problems," and hit me with Haldol, and then got upset that I had a panic attack from it, and then I had to drive 3 hours to UCSF and then was admitted to the hospital.
Wow. I know we've all been through a lot with this stuff, and it doesn't, you know, the privacy of our medical records is one of the only things that shields us from a lot of really bad discrimination and consequences for us. So yeah, I gave it to Mr. Ellenberg on this one. And Tiffany?
Yeah, to Tanya's point, I had to go and you know, ask that a psychiatrist reevaluate me.
Yeah.
And put into my record what my diagnosis is and that I do not qualify for the previous incorrect diagnosis.
Yeah.
Another thing is, you know, unfortunately, I am really careful about reading all of my doctor's notes when they go into the system, because I did have a physician who, as you know, I'll just disclose, I have chronic pain conditions. I have to sometimes use rescue medication to keep me from going to the ER. And they put opioid dependency disorder into my file. And I called up the office and I said, that has to come out right now. Like I disclosed to you guys that I have these medications for emergencies, you know, you have to take out, I do not have a disorder, and because they will treat you very badly. So just a heads up, if you do have that kind of a situation, I did get that removed. They revised the note.
Wow, that's wild. I don't read them because of me. They always say stigmatize things about me and I would get grumpy. So I don't read my medical records.
Yeah, living with disabilities is wild, man.
It is. It is. It's an uphill battle. All right. I'm not seeing any other questions or discussions. Thanks so much for joining us. And I will do some Prop 1 more Prop 1 implementation stuff as soon as I have a little bit of capacity to put it together and get it out to y'all. So watch your listserv. Thank you.
Can I get your name again, please?
Yeah, my name's Claire Courtright.
Last name is,
Cortright.
okay, thank you.
Nice to meet you, Mary Jo. Bye.
Oh. Steve, I think you might have sent me a message, but I can't find it. So just an FYI on that, it's, you know, I'm not seeing it coming through. But it's saying that I have a direct message.